Yes.
May it please the Lordship.
Yes.
Lordship, I beg to mention items 12 and 13. Items 12 and 13.
Item
12 and 13.
12 and 13.
Lordship. Lordship, here I am appearing for the respondent claimants. The appellants are yet to serve the copy of the IAs. So if the appellants can be directed to serve the copies, and accordingly, we will be filing our objection. So if the matter can come out after 3 weeks.
Who is appearing for the this thing? Appellants? Nobody is appearing. Mr. So and so, your name?
Nongosa, on behalf of the claimant.
Appearing on behalf of the respondent submits that respondent is yet to receive the copy of the IAs that have been filed in the MSc appeals. Therefore, he submits that copy. Therefore, he submits that a direction should be given for serving the copies to them, so that they can so that he can file the affidavit in opposition.
The objection.
The objection to the IAs.
Lordship.
Prayer is allowed. Let the matter be fixed after 3 weeks. In the meantime, the counsel for the appellant shall provide the copies of the IAs to the counsel for the respondents.
Much obliged.
My Lord.
Yes.
My Lord, I beg to mention item 4.
Item
I am for the
4.
petitioner.
Yes.
Lordship, if the matter can come up to 2 weeks.
Item number 4.
On 4.
Mr. So-and-so appearing on behalf of the petitioner submits that he has some personal difficulties today.
Lordship, the leading counsel, he is out of station.
He submits that the leading counsel in the matter is out of station, and therefore he prays for adjournment of the matter for 2 weeks. Prayer is allowed. Let the matter be fixed after 2 weeks. Mr. So-and-so, you are appearing in the matter?
Yes, Your Lordship, for the state.
Mr. So-and-so appears for?
For the state.
For the state.
And for private respondent 6.
Mr. So-and-so appears for? Private respondent number?
6.
6.
Yes, ma'am.
6.
Hello.
My Lord, I beg to mention item 11.
Item 11.
Yes, my Lord.
Yes.
Affidavit is under preparation, so may I pray that 3 weeks' time may be granted for the state.
For the
sole
prayer of the
respondent.
learned counsel appearing for the petitioner, let the matter be fixed after 3 weeks.
I'm much obliged.
Lordship, I beg to mention item number 27.
27.
27. 2 weeks may be allowed, Your Honor.
On the prayer of the learned counsel appearing for the petitioner,
Lordship.
the matter let the matter be fixed after 3 weeks.
I'm for appearing on behalf of my senior for respondent number 5.
MS so-and-so appears for the respondent.
May I please, my Lord? My Lord, I beg to mention item number 28, hearing item number 28 to 31.
28.
To 31. Here we are relying on the judgment passed by a coordinate bench, and the judgment is in appeal now. So if this matter can be taken after the disposal of that appeal.
You are relying on a
Judgment passed by a coordinate bench in WPC 38 and 39 of 2023. And that judgment has been appealed by the center. So I pray that this matter may be
The
taken
learned
up.
counsel appearing for the petitioner submits that a similar matter. A similar matter.
I have the number of the writ appeal.
You have the number of the writ appeal?
Yes.
Submits that the judgment that he is relied on for this matter has been challenged before the division bench of the Honorable Gauhati High Court.
Yes.
Therefore, he submits that this petition should be listed after hearing of the appeal before the division bench. Hearing of the appeal by the division bench.
Writ appeal 12 and 13 of 2025.
You just write the writ appeal number also. Prayer is allowed, let the matter be fixed after.
After the disposal of the writ appeal, maybe
That,
list.
I mean, we cannot keep it like that. I mean, list the matter after 6 weeks.
6 weeks.
6 weeks.
Obliged.
May I have this, Your Lordship? Your Lordship, I beg to mention item number 9.
Yes.
Your Lordship, I'm for the respondent number 1. We are yet to receive our instructions to file our affidavit, so 3 weeks' time may be given to me. Your Lordship.
Affidavits are ready.
No, Your Lordship. We are yet to receive an instructions.
Mr. So-and-so, you are learned CGSC.
Yes, Your Lord.
Learned CGSC appearing for the respondent submits that he is yet to receive the instructions and therefore prays for 2 weeks' time. Prayer is allowed. Let the matter be fixed after 2 weeks.
Lordship is an interim. Can I let it
The interim
continue?
order so passed earlier shall continue till the next date of listing.
Highly obliged. Obliged.
May I please, Your Lordship? May I be pleased to mention item number 2 and 3, Your Lordship.
Item
On
number
behalf
2
of
and-
my colleague, Inaholi, Your Lordship, I'm informed that the pleadings have been completed, Your Lordship. Pleadings have been completed. 2 and 3, Your Lordship.
On the prayer of on the prayer of so-and-so learned counsel appearing for the,
For AIM, Your Lordship.
for respondents,
Your Lordship, for the state, from the state.
appearing for the state government submits that pleadings are completed in the matter, therefore prays that the matter should be, matter may be listed for hearing.
Yes, Your Lordship, in the usual course.
Let matters to be listed for hearing. Prayer is allowed, let the matters be fixed for hearing after 2 weeks.
Your Lordship, I also beg to mention item number 14, Your Lordship, on behalf of AIM, Your Lordship. Your Lordship, we are here, she is yet to receive instruction, Your Lordship.
Learned so-and-so appearing on behalf of learned counsel so-and-so submits that she is yet to receive the instructions in the matter. Government advocate
Yes, Your Lordship, Government.
for the respondents, submits that she is yet to receive the instructions. Therefore prays for 2 weeks' time granted. This is the matter after 2 weeks.
Your Lordship, item 16 also, Your Lordship, on behalf of Inaholi, she is yet to receive instruction. Yes, Your Lordship.
Same order, na?
Same
Number
order.
16.
Item number 16. Your Lordship, again, Your Lordship, on the same prayer for item 19 and 20 also, yet to receive instruction.
19 and 20 also.
Yes,
Same,
Your Lordship.
same order, 19, 20. Any more?
Yes, Your Lordship, item 41, Your Lordship.
Item 41.
Your Lordship. On behalf of AIM, Your Lordship. Your Lordship, it seems that IA is for impleadment of the AG, Your Lordship. And as far as the COP is concerned, Your Lordship, I'm informed that the pension has
So who
already...
is appearing for the petitioner?
Your Lordship.
Item number 41, you are appearing?
Yes, Lordship.
You are appearing?
Yes, Lordship. Lordship, here we have filed the IA for impleadment of respondent number 11.
So, Your Lordship, let the matter come up after a week, Your Lordship,
Why is
because...
this I is only for implement? Do you have any objections to that?
Okay. Okay, let it come severally then.
Well, let it come.
Please, Your Lordship. Lordship, I beg to mention item 7.
Item 7.
Yes, I'm here to receive instructions, so I pray for 3 weeks on
You are
behalf of the
appearing
state. For the state respondents, Your Lordship.
Mr. So-and-so appearing for the respondent state submits that he is yet to receive the instructions in the matter and therefore prays for 2 weeks' time.
3 weeks, Your Lordship.
3 weeks' time, let the matter be fixed after 3 weeks.
Oblige, Your Lordship.
Next, my Lord. My Lord, I beg to mention item 1.
Item number 1.
Lordship is a joint prayer. The councils have some difficulties today. So if the matter can come after 2 weeks,
On the joint prayer of the councils appearing for the petitioner and respondent, let the matter be fixed after 2 weeks.
Lordship is an interim. Can I
The
let it
interim
continue?
order so passed earlier shall continue till the next date of listing.
Highly obliged.
My pleasure, Lordship. Lordship, I beg to mention item number 17.
Item number
17.
17.
Lordship.
Yes,
Here I am ready to receive instructions, so kindly grant 3 weeks' time to file my affidavit.
same order, no? Not
Lordship,
received, instructions not received. Then,
Lordship, similar prayer with item number 22.
item number
22.
22.
Lordship.
22 also same prayer.
Lordship, 23 as well.
23 also.
Lordship.
Why you are not receiving these instructions? Why all the matters are being mentioned? I mean, almost all the matters are being mentioned. The government council should be ready with the instructions.
Lordship. I oblige, Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 6.
Item number 6.
Yes, Your Lordship.
Yes, what has happened?
Kindly grant me 4 weeks' time to file my affidavit in reply.
Affidavit in reply.
Yes, Your Lordship.
For the private respondent number,
Mr. So-and-so
Four and
appears
five.
for the petitioner.
Lordship, there's an interim.
Huh?
There's an interim.
Appears for the petitioner and submits that she needs 3 weeks' time.
4 weeks.
3 weeks is sufficient. 3 weeks' time for file the affidavit in reply to the affidavit in opposition filed by the respondents. Mr. So-and-so.
I, Jamir, for respondent number 4 and 5.
Appears for respondent number 5. Prayer is allowed. Let the matter be fixed after 3 weeks.
Oblige.
May I please the Lordship? Lordship, I beg to mention item number 10, Lordship.
Item number 10.
Lordship, here the state is yet to file a counter affidavit, Lordship. If Lordship may please to grant 3 weeks' time, Lordship, to file.
May it please your Lordship. Lordship, if a direction may be given to file the affidavit at the earliest.
Lordship.
Mr. So-and-so, the learned government advocate,
Lordship.
appearing for the respondent submits that he is yet to receive the instructions and therefore prays for 2 weeks' time
To file an affidavit.
to file the affidavit in opposition. Mr. So-and-so appears for the petitioner. Let the matter be fixed after 2 weeks.
Oblige. After 3 weeks, Lordship. After 3 weeks, Lordship.
After 2 weeks. 2 weeks are fine.
May I please, Your Lordship? I beg to mention item 24
Item 24.
from the orders.
Yes, what happened?
Service upon respondent 2 is completed, but for 3 it's still awaited. So kindly list the matter after 3 weeks.
MS So-and-so, learned counsel appearing for the petitioner. Petitioner submits the service of notice on respondent number.
2 is completed, but 3 is still awaited.
Respondent number 3 is yet to be completed. Therefore, sit prays for 2 weeks' time. Prayer is granted. Let the matter be fixed after 2 weeks.
Oblige.
My pleasure, Lordship. Lordship, I beg to mention item number 8.
Item number 8.
On behalf of S. Chang. Kindly grant 3 weeks' time to file affidavit.
For government.
Lordship.
The same prayer. Government council hasn't received the instructions. Same order. Okay. Yes.
Lordship, item number 15 as well.
15 as well.
Similar prayer, Lordship.
The government advocates are not filing their affidavits. Why?
Lordship, I am instructed that she's yet to receive instruction.
The instructions should have been received by this time. The proper follow-up should have been carried out.
Lordship, there is an interim order.
The interim order so passed earlier shall continue till the next date of listing. Yes.
Lordship, item number 21 also on
Item
behalf
number?
of S. Chang. 21.
21 also.
Lordship.
Same prayer, same order.
I oblige.
May I please, Your Lordship? Lordship, I beg to mention hearing item number 26 on behalf of my senior IMT Longchar. Lordship, here.
He's not available.
Yes, Lordship.
The prayer of so-and-so, learned so-and-so appearing for. Yes, senior's name?
IMT Longchar.
So-and-so, the conducting council, the matter. Submits that the conducting council is not available today in the court, therefore prays for 2 weeks' time.
Lordship.
Prayer is allowed, let the matter be fixed after 2 weeks. After 2 weeks.
Lordship. Much obliged.
May I please, Your Lordship? Madam, I beg to mention orders item number 25. Here, notice upon respondent number 7 is still awaited.
You write item number?
25.
25. MS so-and-so appearing for the petitioner.
Yes, Lordship.
Appearing for the petitioner submits that service of notice on respondent number
7.
7 is yet to be completed. Let the matter be fixed after 2 weeks.
Obliged, my lord.
Obliged, Your Lordship.
For motion from the supplementary course list, item number 32.
Yes, you have received some instructions?
Yes, Your Lordship. I received the church sheet, Your Lordship, as well as the CD, Your Lordship. So, Your Lordship, there's some money transaction being done in his account. So, because of that, his involvement has been stated in the in the church sheet and stated that they've been evading arrest. That's why, and it is stated that he has been absconding. That's why. That is the reason only, Your Lordship.
Can I have the CD?
Yes, Your Lordship. The first one is the church sheet and the second is CD. It was only during the investigation of the
His name
interrogation.
he's not church sheeted, right?
It's charge sheeted against him also, and
He's
that's why.
suspended. What
Yes,
is
on
his-
the last page, Your Lordship, a charge sheet on the last page.
So charge sheet has already been filed. We appear before the court. We
Yes,
appear
Your
before the NDPS court.
Yes, Your
There's
Lordship.
nothing there in
my
the
lord.
AB now.
My lord, please allow me to make a brief submission. Since it is not a commercial quantity, it is an intermediate quantity.
No, whatever, charge sheet, no, whatever it may be, charge sheet has already been filed, so you need to appear before the court. So I can give you only the interim
Yes,
for
Your-
appearance before the
Yes,
court.
Your Lordship. Yes, Your Lordship.
Okay. Heard Mr. So-and-so, also heard MS so-and-so, the learned PP for the state. This is an application of the section 482 of BNSS 2023 for granting pre-arrest bail to the accused applicant in connection with GR 07/2024 registered under section 21 small b NDPS Act 1985 pending before the learned special judge NDPS Act at when, where?
Longlang.
Special judge?
Longland, Your Lordship.
Longlang. Longlang district in Nagaland. Okay. The learned PP appearing for the state submits that charge sheet in the instant matter has already been submitted by search sheet number 64/2024 dated 10/12/2024 before the learned special judge Longlang, Nagaland. In view of the aforesaid, she submits that nothing survives in the matter and the accused applicant should be directed to appear before the concerned court, that is the special court, that is the learned special judge Longlang, Nagaland. Whereas the learned, next paragraph, when the learned counsel appearing for the accused applicant submits that he should be given some interim relief so that he can appear before the learned
special judge.
Longlang, Nagaland. In view of the aforesaid submissions and taking into account that the charge sheet has already been filed, this court is of the view that the accused applicant should be given an interim pre-arrest bail so that he can appear before the learned special judge
NDPS.
Nagaland. Full stop. In view of the aforesaid, it is directed that in the event of the arrest of the accused applicant by the investigating authority, the accused applicant shall be granted interim pre-arrest bail on furnishing of a bail bond of rupees 30,000 with a surety of like nature to the satisfaction of the arresting authority.
Your Lordship, if the surety should be one government servant, Your Lordship, because since he is from he's outside Nagaland, Your Lordship.
Okay, right, then change it to one surety of any government servant serving in Nagaland.
Your Lordship, if they don't get in Nagaland, but in Manipur also, it will do.
Surety of a government servant with the following conditions. When can you appear?
At least 2 weeks may be given. I also that the court does not sit regularly in Longlang.
No, I'll inform Your Lordship, also the Peshkar. I'll inform Your Lordship.
So you appear before within 2 weeks of this order, okay?
Yes, ma'am.
With the following conditions that first one, the accused applicant shall appear before the learned special judge Longlang, Nagaland, within 2 weeks of passing of the instant order. Number two, that the accused applicant shall cooperate with the investigation and make himself available before the learned before the investigating authority and or the learned counsel, special judge Longlang, as and when called for. Third, the accused applicant shall not try to tamper or hamper with the investigation process in the instant matter. In view of the aforesaid direction, this instant pre-arrest bail application is disposed of. We will not give interim. We'll give because he's going to appear only.
Your Lordship, in case he doesn't appear, that becomes a problem. So let him appear, and on the next date he can bring a report, and if it's complied, then finish. But if he did not cooperate, then maybe we have to have a thought on that. So
let this
Lord,
matter.
since all the other accused on bail, and 5 accused are already out on bail, and he's
They are
innocent.
already on bail.
yes, that is the thing. However, let him appear, Your Lordship. Firstly, let him appear, and Your Lordship, let him comply with the court.
If he doesn't appear, you are always, you are always at liberty to come to this court and pray for cancellation of the bail.
Yes, madam.
You can always do that. But there is no point keeping this pending because he will appear.
Yes, madam.
I'll leave
In
it
view
to
of the aforesaid directions, the instant interim, you remove that interim part, okay? In view of the aforesaid, this instant pre-arrest bill application is disposed of.
Your Lordship, then operative portion that in the event does not bear, then I'll have a liberty to.
That you always have it. That we need not mention about this. You can always have it.
Oh, Your Lordship.
Because other persons are already on bail.
Yes, that
Correct?
yeah.
So looking into that, you please, write one sentence also. I will arrange it so that this has been submitted by the learned counsel for the accused applicant, that other accused persons who were charge sheeted, right?
Yes.
Other accused persons who have been who have been charge sheeted are already on bail.
5.
You just type it out. I'll arrange it. Okay, that sentence I'll just put it.
Much obliged.
For motion, item number 33.
You can take back this charge sheet and this thing.
May I please, Your Lordship? Your Lordship, this writ petition is filed challenging the illegality and enforceability of the office memorandum dated 22nd of September 2004 and 17th of March 2015 for the work charge employees issued by the state government, my lord. The petitioner contends that the state office memorandums are arbitrary, illegal, and violative of the
You are challenging what? You are challenging
office memorandum dated 22nd of September 2004, which is in my Annexure 55, Your Lordship, particularly clause 2, 3, and 4, my Lord.
Annexure?
Annexure 12, page 55. Particularly, Your Lordship, clause 2, 3, and 4, where it is stated that regularization will be done against 50% of all future vacancies, my Lord.
Regularization of workers'
Yes,
employees
Your
will be
Lordship.
done against available regular vacancies.
Yes, Your Lordship.
50% of regular vacancies of similar nature arising in a year will be reserved for regularization of workers' employees, and the remaining 50% will be filled as per normal rules of recruitment. And number 2, 3, and
2, 3, and 4, my Lord.
4, the workers' employees will have right to be considered. Now, what has happened in your
And
case? The petitioner, what has happened?
The petition does not come within this threshold, Your Lordship. It's outside this threshold. And Your Lordship, also office memorandum dated 17th of March 2015, that is in my Annexure 57. Here, Your Lordship, the office memorandum explicitly states that those work charge employees who have completed 30 years of service will be regularized and given pensioner benefits.
Where is that? Where is that? Page 57?
Yes, page 57, Annexure.
57.11. All existing workers, casual employees, various departments who are enjoying scale pay, who have completed 30 years or more, or continuous service and so will be regularized.
Yes, Your Lordship.
Why are you challenging this?
Because, Your Lordship, the petitioner, after serving, the fact that the petitioner, after serving for 27 year of service, in scale of pay, Your Lordship, he is not given the benefit because he does not come under the purview of 2004 memorandum as well as the 2015 memorandum, which is discriminatory, Your Lordship, and violative of the fundamental rights, Your Lordship. So this memorandum has to be, Lordship, quashed and set aside, my Lord.
This memorandum issued by whom? State of Nagaland?
Yes, Your Lordship. Personal and Administrative Reforms Department.
But you have already been reserved, this thing.
I'm not covered, Your Lordship.
No, you are already retired.
Already retired, my Lord. Already retired. After serving for 27 years on completion of 60 years of service, my Lord.
Then you should have challenged it at that point of time only. Now
Your Lordship, prior to his retirement of service, he has also served application to the state respondents.
When? Where
it's
is
in my page 28, Your Lordship, Annexure 3, but the type copy is in Annexure 3A, page number 29, my Lord.
Page number 29?
Yes, Your Lordship.
Page type copy is that? Page 30?
Your Lordship,
page 30?
Page 30, that is forwarding letter, and page 28, that is the prayer for regularization that the petitioner has served to the respondent, Your Lordship.
Page 28?
Yes, Your Lordship,
Where is
Annexure
that?
3.
Is there a type copy? No. But you have not raised about anything about, the issue about this office memorandum. Did you raise any issue about the office memorandum earlier? No.
No, Your Lordship, because the petitioner...
You have not filed any representation also saying that that is violative or that has actually...
Yes, Your Lordship, but I have stated in my writ petition. I have stated in my writ petition.
No, that you have stated in the petition, but,
Yes,
but you should have come before this court a little bit earlier, because now you have already retired.
I was retired just last year only.
Correct.
Yes,
so before retirement, you should have come. This is a notification of 2015.
Lordship.
And one is 2004.
Yes, Your Lordship, but in pensioner, for pensioner, Your Lordship, there is no delay. There is no delay, Your Lordship, for pensioners. So
No, not, I'm not talking about, pensioner or whatever. This notification has come long time back. You have been serving in the department for
Lordship.
last 27 years. That you have submitted.
Yes,
Correct.
Lordship,
Now
Lordship.
you should have at least filed a representation before the department saying that because of this OM you have been deprived or you were not getting whatever you should
Your
have got.
Lordship is correct.
That you have not done. Now after the retirement you have come before this court.
Yes, Lordship. If Your Lordship may kindly issue notice.
Heard we have MS.
Arats Lakibs.
Heard MS so and so. Also heard
Pichano for the state.
for appearing for respondent numbers.
1 to 6.
Respondent number 1 to 6. The instant writ petition has been filed by the petitioner challenging certain, which were this certain provisions of the office memorandum dated 22/9/2024, as well as the office memorandum dated 24/5/2005, alleging that due to the aforesaid provisions, due to the provisions under challenge, the petitioner has been deprived of his regularization in the department of PWD in bracket RNB, in the office of the executive engineer PWD in bracket RNB. This is 40 division. How do you pronounce this? PFT?
Futsero.
Futsero.
Yes.
Futsero division. Futsero division. The learned counsel appearing for the petitioner submits that this is lady C. Submits that after serving the department for about 27 years.
Yes, Lordship.
27 years, she retired from service on 30/4/2024 without her service being regularized, and thereby she has been deprived of her pensionary and other benefits for her services rendered to the department. She submits, the learned counsel submits that the petitioner had earlier submitted applications dated 2/6/2023 and 26/4/2024 to the engineer-in-chief and PWD Kohima, praying for regularization of her service, but she did not get any reply or response from the aforesaid department. The learned counsel submits that the petitioner is praying for interference of this court on the ground that the aforesaid OM dated 29/22 certain provisions, that is, only these provisions you are challenging, right?
Yes, Your Lordship.
Certain provisions, that is 2, 3 and 4.
Yes, that is Office Memorandum 22/9/2004, clause 2, 3 and 4.
That is clause 2, small Roman, clause 2, clause 3, clause 4 of the memorandum dated 22/9/2024,
2004.
2004, as well as clause 1,
Bracket
capital,
1
capital
and 2.
1 in bracket small 1 of the memorandum dated 17 March 2015. 15, as the same being discriminatory and illegal, which deprived the petitioner of her regularization in spite of working in the department for, in spite of serving the department for 27 years till her superannuation. Full stop. Issue notice returnable in 4 weeks. Returnable in 4 weeks. Returnable in 4 weeks since MS so and so, the learned government council enters appearance in the matter for all the respondents. This usual service is dispensed with. Usual service of notice is dispensed with. However, extra copies of requisite number of the petition of the petition shall be served to the government council within
2 days.
Within 2 days from today. Let the matter be listed after 4 weeks.
Are you pledged, my
I
lord?
pledge.
For motion, item number 34.
May I please, Your Lordship? Lordship, by this writ petition, the petitioner is challenging the approval letter that was issued by the respondent number 2 for issuing the new fair price shop license to the respondent number 7, Lordship. So, Lordship, the brief fact, Lordship, I have annexed the approval is at annexure.
You are challenging the approval letter.
Yes, Lordship. That is that approval letter stated for issue of new license to the respondent number 7, Lordship.
Approval, where is
Yes.
the approval letter?
Page 62, annexure P, Lordship.
Page 62.
Lordship.
Yes, approval for issue of licenses under so and so. On a
Yes.
subject of your letter reference and convey the approval, the issue of fair price of licenses to under mentioned applicants leasing, basing on your recommendation. So why you are challenging this?
Lordship, here, the approval letter was issued without issuing notice to the, without any prior notice to the petitioner, Lordship.
Why petitioner is required to be given notice? Because he has a fair price shop.
Yes, Lordship. Initially, the petitioner, till now, Lordship, he has the license, and Lordship, his license was extended in the year 2022, Lordship. He was issued with a license.
Extended for how many years?
It was extended from 1 year, and again after that, it was extended till the 31st March of 2025, Lordship. And after that, he has also applied for the extension in the year last.
Is there any law that a notice should be given?
Yes, Lordship. Yes, Lordship.
Where
It's
is
there.
that?
Lordship, if my Lord may kindly turn to page 51, that is the type copy, Lordship.
Page 51.
Yes, Lordship.
This
That
is
is
deed
the
of
type
agreement.
copy. Yes, Lordship. In the deed of agreement, Lordship, this is part of the license, Lordship. So at para 2, Lordship.
Para 2.
Yes, Lordship.
This agreement remain force.
So prior to the cancellation or any issue of new license, Lordship, it has to be given a notice, Lordship. And in fact, Lordship may also kindly see the para
But
10.
your license is not cancelled.
No, Lordship. No, Lordship. Only the approval, yes. But in place of the, yes, Lordship.
Only an approval has been given for a different fair
For
price
issue
shop.
of, yes. But
So whether two fair price shops can exist together?
no, Lordship. The petitioner's license has to be cancelled, Lordship. And on the same place, in place of the petitioner, it has to be replaced by the other person. So without any notice, they have issued that new approval for issue of license, Lordship.
Heard, Ms. Sorensen?
Lordship, I have an interim prayer, Lordship.
Lordship, as far as issuance of the notice is concerned, Lordship, notice may be issued, but I have objection to the interim, Your Lordship.
Why?
Lordship, may kindly come to page 32.
Page 32.
Yes.
Yes.
This is the permit. And the permit,
Page 32.
32. The Lordship.
Why it has been just...
Lordship, Lordship, in fact, this is the second round of litigation, Lordship. Lordship, this license initially, while the petitioner was serving, till before the expiry of the petitioner's license, Lordship, the government on 26/9, this was cancelled. Even this was cancelled without a notice. So, being aggrieved by...
So you came to the court? Then
Yes,
the
Lordship.
Court has given an order.
Yes, there was interim, and during the pendency, the respondent who was acquaintance to the respondent number 7 approached the private respondent, approached the petitioner to withdraw the case, to settle the matter amicably, and the issue was settled. Until this year, Lordship, in fact, there was no issue or no interference from any other party, Lordship. However, on the third week of this month, Lordship, the petitioner came to know that this approval notice has been issued. Until that, there is no disturbance from any other party, Lordship. So we withdrew the... Yes, Lordship. So we withdrew the petition, Lordship.
Lordship, yes. The validity is only up to 31st of March 2025.
Correct.
Yes. So the validity expired. Thereafter, Your Lordship, if you see, the approval was given on the 26th of June. That is only after the expiry of the validity period, Your Lordship.
It was not extended.
It was not extended. It was not extended. Now, Your Lordship, if the interim prayer stay in this particular approval order is issued.
But if I do not issue any interim, this will become infructuous. What is the point of
No, Your Lordship.
on this?
If interim prayer is issued, Your Lordship, if interim prayer is issued, then the poor beneficiaries will be affected, Your Lordship.
No, I mean, for a time being, then he's still running the shop, right?
Yes, Lordship.
Lordship, how can he run the show when the validity period has already been expired?
Then,
No, Lordship.
Whether he has closed down the shop.
That
or
is-
No,
authority
Lordship.
has
Yes,
closed down the shop.
that is one thing. Second thing is,
why the authority has taken so much of time to approve it till June? Why it was not approved earlier, before expiry, or at least after the expiry, immediately after the expiry?
No, Your Lordship.
No, why the authority has taken 3 months of time for approval?
no, Your Lordship,
During this time, what has happened to the shop? It is running or not?
that we will file an affidavit. As far as the interim is concerned, only the interim is concerned, Your Lordship. At least, not today, Your Lordship. Let me get instruction whether this approval, license has been issued to this person or not.
No, this is only approval. She is not submitting that license has been issued. Correct?
No, therefore, Your Lordship, because this was issued in the month of June, now it is October. License must have been issued by now, who knows, Your Lordship. So if license has been issued, Your Lordship, then the poor beneficiaries will be affected. And that license also has to be challenged then, Your Lordship, in that case. So at least not today, Your Lordship. Notice may be issued, I have got no objection to that. I'm just objecting the interim prayer, Your Lordship.
If I may, Lordship. Lordship, I object to the submission. Lordship, in fact, the petitioner has applied for extension in the month of April. He has also given a rupees of 500 for extension, and the original license is under the custody of the state respondent. Until that, they have not given back the license to him. But from after the expiry also, he has been continuously distributing the essential commodities to the beneficiaries, Lordship. So if at this point of time, if it's not state, Lordship, it will affect not only the petitioner, but also to the beneficiary. So, Lordship, till the
So what is the
disposal order.
instruction? Whether any license has been given to this person?
No, Lordship, we
Because
inquired, yes,
if
Lordship.
he's correct in one thing, that if the license has already been issued, then you have to challenge the license also.
No, Lordship, it seems we also inquired about that, but it seems they have not started with the processing of the license, Lordship. And in fact,
You take your instructions, we'll fix it in the next week. I mean, till that time, we'll state this.
Lordship.
Lordship.
They come, we will fix it in the next week. If license has been issued, then she has to challenge it. You were right in that.
Your Lordship, I am just objecting to the interim prayer only for the concern of the... Yes, only for the concern of the beneficiaries, Your Lordship, because the poor beneficiaries, they'll have to collect their...
I will record her submission.
Yes.
Stating that she is distributing this thing and she is still running the shop. So the beneficiaries will not be affected. This is what she is submitting before this court.
That will be, yes, Your Lordship.
I cannot disbelieve her, correct?
But there will be a very strange statement, Your Lordship, because fair price shops license being cancelled and the essential commodities being sent to that particular shop again.
Her license has not been cancelled as yet. She has applied for extension, but though no action has been taken by the department, that's what she is submitting.
Yes.
So that hasn't been cancelled. without cancelling that, you're correct that like this has already expired.
Yes.
But only thing is that in the meantime, they have not issued the license to anybody else. So fair price shop should run.
Yes,
So
should
people-
run,
people
Your
should not be affected.
Yes, yes.
So she is doing that, say her client is still running the shop. So in between, if I do not give her some interim relief and like suddenly something happens, then it will be a problem.
Yes, Your
So
Lordship.
it's better like, I mean, we
Yes.
give her an interim for a short period so that you come up with your instruction, you file an affidavit. If somebody else has been given a license, then she has to obviously challenge it.
Yes. Then Your Lordship kindly record her statement that she is still running that.
That's
Lordship.
that is the first statement she is.
Lordship. Yes, because the beneficiaries should not be affected, Your Lordship,
No,
because these are poor
beneficiaries-
people. Yes.
Obviously, we'll have to, that is the first priority.
Yes, Your Lordship.
Otherwise, the object of, having this fair price shop is not there.
Correct.
Will not be
And
there.
staying these things, Your Lordship.
Yes,
Yes.
since he's running this, let her
Correct.
run.
If
till-
that is recorded, Your Lordship.
Let her run. Heard MS so and so, the learned counsel appearing for the petitioner, also heard, I just forgot your name, sorry.
And Angami, Your Lordship.
And Angami, the learned government advocate.
Senior government
Learned
advocate.
senior government advocate appearing for,
Respondent 1 to 6, my Lord.
appearing for all the respondents.
No, Your Lordship. Respondent number 7 is a private respondent, my Lord.
Okay, respondent number 1 to
6, my
6. The instant writ petition has been filed by the petitioner challenging the approval letter dated 26 June 2025, conveying the approval letter dated 26 so and so, approving the issue of new license of fair price shop to Sri Vito Aomi, VITOAWOMI, Aomi, in bracket respondent and number 7, without issuing a notice or any cancellation order to the petitioner. The petitioner, the learned counsel for the petitioner submits that in terms of, where is that agreement in terms of?
Agreement is at page 31, Annex Your Lordship. The relevant portion is at page 51.
In terms of the fair price shop guidelines. No, where is that deed of agreement?
51, Lordship.
Yeah, this agreement is as per the guidelines, right?
Yes, Lordship. Deed of agreement is 46, and the relevant portion is at page 51.
As per the fair price shop guidelines, a deed of agreement is required to be entered into between the respondent government and the licensor, and the licensee, and the licensee, and accordingly, the petitioner had entered into a deed of agreement on 1st April 2024, which provides that the agreement shall remain in force The date is not there. Page 51.
Lordship, it was made on 1st April of 2024, Lordship.
Correct, for remain in force till which time? You have not put this date here.
Yes, Lordship,
The
it is.
shall remain in force for 1 year. It is for a 1 year term?
Lordship.
For 1 year, and the agreement may be terminated earlier by either party with 2 calendar month notice given in writing to the other party to that effect. The learned counsel for the petitioner submits that though the term for the license is already over on 31st March 2025, the petitioner has already submitted an application. Where is your application? Application.
Lordship, it's not application, it's just the amount and the license that has to be produced before the concerned authorities, Lordship.
Submits that the petitioner has already submitted the required amount as well as what?
As well as the license, the original license.
As well as the original license before the concerned authority for extension of the term of the license. However, till date, nothing has been done by the respondent authorities. See, she submits that she submits that till date the licensee, that is the petitioner, is running the fair price shop and distributing the goods to the general public without fail, and therefore the petitioner was expecting that his license will be extended for another term, full stop. However, to his utter surprise, the petitioner has found out that behind the back, and without giving any notice or giving any intimation to the petitioner, the government authorities has issued the approval for issue of EPS licenses under Junheboto, ZUNHEBOTO district Junheboto on which date?
26 June.
On 26 June 2025. The Learned Counsel for the petitioner submits that such action of the respondent authorities is against the settled law, and against the provisions of the deed of agreement which was signed in between the parties, as well as against the provisions of fair price shop guidelines. In view of the aforesaid, the Learned Counsel submits that this court should issue notice in the instant matter, and also praise for an interim order by staying the aforesaid approval dated 26 June 2025 issued by the respondent authorities. On the other hand, Mr. So-and-so, Mr. Jamir, Mr. Angami, the learned senior government advocate submits that since the approval has already been granted, and he is not having the instruction whether the license is already issued or not, at this stage the interim order of stay of the approval should not be granted by this court. That's all your submissions? After hearing the parties, and taking the whole matter into consideration, this court is of the view that the public that this is a fit case wherein an interim order should be passed by staying the aforesaid approval notice, staying the aforesaid approval dated 26 June 2025. Issue notice to the respondents, full stop. The formal notice to the respondent number 1 to 6 is dispensed with as the learned senior government counsel enters appearance. However, requisite number of extra copies shall be served to the senior government advocate within 2 days from today. Then issue notice to respondent number 7 shall be taken taken by speed post within a period of 3 days from today. Let the matter be fixed after when?
Your Lordship, after 4 weeks, because notice has been issued now,
After 4 weeks.
Your Lordship.
Much obliged, Lordship.
This will do? Serve the purpose?
Lordship. Much obliged, Lordship.
Deeply obliged, my Lord.
For motion, item number 35.
May I please, Your Lordship?
Yes.
Lordship, here the petitioner was appointed as a workers' fixed labor on 1/6 of 1976. And also, Lordship, he was released by common release order with effect. He was released with effect from 31/7/2011 after serving
27?
released from service
When?
with effect from 31/7/2011. Annexure 3, Lordship, Annexure 2, Lordship,
And
page
you have
10.
come to this court after how many years?
Almost a decade, Lordship. Almost a decade, Lordship. Then
Why should I consider this?
Lordship, here at para 1, Lordship, page 4.
Yes.
The second paragraph, that is the petitioner is illiterate and belongs to the Kimyongan tribe.
That, I mean, you are a lawyer, you know about this. Like if illiteracy is a ground for coming to the court late.
Lordship, the
I mean,
petitioner.
it is almost how many years? It's more than a decade.
Yes, Lordship.
Now, this cannot be considered.
Lordship, the petitioner.
So if you have any judicial pronouncements by the Supreme Court saying that after a decade also you can approach this court and delay and the principle of delay and laches will not apply, then I'll consider your case.
Lordship, the petitioner being illiterate, they were not aware of.
That is not a ground. Please take that. I will not consider this. I mean, delay of, so many years. I mean, Supreme Court has settled these issues. Heard Mr. So-and-so, the learned counsel appearing for the petitioner. Also heard
And approve. For respondent number 9, Lordship.
respondent number 9 and
For respondent number 1 to 8, Lordship, for the state respondents.
MS so-and-so for respondent number 1 to
1 to 8.
1 to 8. This petition has been filed under Article 226 of the Constitution of India. Constitution of India for non-consideration of the representation of the petitioner dated 16/5/2025 submitted to the executive engineer, PWD in bracket housing, Tuensang Division, Tuensang, Nagaland, for grant of scale of pay and regulation of service for pension and benefits. The petitioner was appointed as work charge employee at fixed pay on 1/6/1976 under the establishment of subdivisional officer, Public Works Department in bracket housing, Tuensang, Nagaland. On completion of 35 years of service, the petitioner was released from service with effect from 31/7/2011 in terms of Nagaland State Employment Retirement in bracket Second Amendment bracket complete, Act 2009. Till 2000, after his retirement, after his release of service on 31/7/2011 till 2025, till May 2025, the petitioner did not raise any question about his release. The petitioner neither raised any question regarding his release nor approached the concerned authorities for any pensionary benefits for regularization or for regularization or any pensionary benefit. However, on 16/5/2025, the petitioner has submitted a representation dated 16/5/2025 to the Executive Engineer PWD Housing, Tuensang Division, Tuensang, Nagaland, for grant of scale of pay and regularization of service for pensionary benefit. Nothing has been done on his representation. The learned counsel appearing for the petitioner submits that the petitioner is an illiterate person and not aware of his legal rights, and therefore he did not approach he neither approached the concerned authority nor this court in time. Therefore, this court should consider his case at this delayed stage also. The councils appearing for the state authorities, however, have submitted that the instant petition should be dismissed on the ground of delay and laches, as the petitioner has not approached this court in time. Okay, there is a submission. Delay and laches. Correct.
No, Chief.
After hearing the parties and finding no explanation as to any explanation and finding no proper ground of such huge delay and laches in filing the instant writ petition, this court is not in favor of entertaining this application, this writ petition at this delayed stage. Accordingly, the instant writ petition is dismissed.
Much obliged.
For admission, item number 5.
My lord. My lord, may kindly allow me to appear through VC.
You're out of station?
My lord, I am in Gauhati. Today I was having another matter in Chief Justice Court, and then I have attended that, and now I am online, Lordship. I am practicing from the principal said only, Lordship.
Okay, yeah, please proceed from there.
Lordship. My lord may kindly come to the last order, that is 7/10/2025, Lordship, in which the respondents have been directed to file
They filed an
the
affidavit, they filed an affidavit in opposition.
Lordship, on
Lordship, in Lordship.
So would you like to file a reply to that?
Lordship,
Lordship, I would like to file my rejoinder within a period of 1 week, Lordship. And thereafter, the next step may be fixed for hearing, Lordship, because more or less the pleadings are complete.
Lordship, in fact, Lordship, I kindly come to the page 25 of the petition.
He wants to file a reply.
Lordship,
Yes,
the prayer of the petitioner is to question set aside the matter that is pending before the vigilance, Lordship. And in fact, the prayer has already been answered, Lordship. Lordship, in fact, I have filed our affidavit stating that the matter has been disposed of, Lordship. Lordship, which I have clearly stated in the paragraph 4 of my affidavit, Lordship. So, Lordship, now the matter, now it become infractious, Lordship.
Paragraph 4.
Paragraph 4, Lordship. Page 2, paragraph 4, Lordship. Earlier it was vigilance, now it's Upalokai.
But the government is yet to take the decision.
Lordship, in fact,
It is-
the government
it
is
is
yet to take a
only-
decision, but if we look at the prayer of the petitioner, Lordship.
They wanted the quashing of this.
Quashing of Lordship,
Quashing of the whole proceedings, right?
Whole proceeding, Lordship.
But like,
Lordship.
Lokaयुक्त has passed an order disposing of the matter.
Disposing of the matter.
Referring, but they have not quashed it. Lokaयुक्त hasn't quashed the proceeding. It has only stated that case is disposed of with the recommendation of the government to put in place proper control and check.
Lordship.
Now we do not know whether the government still wants to go ahead with the case or not.
Lordship, it's still pending, Lordship. But
It's still
however,
pending
Lordship,
consideration of the government. But what do you have to say on this? Yeah, have you gone through the affidavit?
My lord, yes, I've gone through the affidavit I received just day before yesterday only, because of which I could not file on time the necessary rejoinder. So I will file my rejoinder within a period of 1 week, Lordship. And then, my lord, may kindly take decision thereafter, because this is an application filed for quashing of proceedings, including all the investigations done illegally, because of which I would like to.
No, the only thing is
my
that the
lord,
government council is submitting is that the Lokaयुक्त, that the matter was referred to the Lokaयुक्त.
Lordship.
And Lokaयुक्त has disposed of the matter.
Lordship.
Where is his order,
My
Lokaयुक्त?
lord.
One second.
Lokaयुक्त order, which is at page 7, Lordship.
Page 7.
Page 7, annexure bill. That was disposed of.
One second, let me just go through this one. The Lokaयुक्त has not passed any effective order.
Any effective order, but
Only,
however,
only they have disposed of and recommending the government to put somebody in good place. But there were submissions wherein it has been stated before the Lokaयुक्त that Lokaयुक्त may not have jurisdiction to entertain the matter.
Lord.
So now it is pending before the government.
Before the
has to
government to take a decision.
So let him file an affidavit in this matter.
Lordship, in fact,
Lordship,
the prayer one of the petitioner has been answered, Lordship. The prayer number 1 has been already been answered. And in fact, Lordship, since this is a subsequent order that was already been passed, Lordship, if they are agreed by this disposal order of the
Let him file and counter reply to your affidavit. Correct? Because it is still pending in the government because he has challenged the whole proceeding. And
My lord.
let him file. Mr. So and so. What is your name? May I have your name?
NZ Lotha, Lordship.
Angel Lotha.
Lordship.
Mr. So and so, learned counsel appearing for the petitioner submits that he has received the affidavit in opposition filed by the respondent filed by respondent number?
Respondent number 1.
Filed by the respondent number 1 yesterday only. And therefore, he prays that some time should be granted to him for filing a reply to the affidavit in opposition. Prayer is allowed. Let the matter be listed after
3 weeks, Lordship, at the convenience of the registry.
After 3 weeks, after 3 weeks, on a
date
to be fixed by the registry. In the meantime, the learned counsel appearing in the meantime, the petitioner shall file its affidavit.
Rejoinder, Lordship, rejoinder.
Affidavit in reply, correct. He has filed in counter affidavit in opposition. So you'll file an affidavit in reply to that.
Lordship. My apologies.
Is this matter after 3 weeks? That
Lordship.
we have already mentioned. Registry to fix it.
Obliged.
Much obliged, Lordship.
And record his submission, this thing, sir. Mr. So-and-so appears for the respondent number 1.
Lordship.
Your senior government advocate?
No, Lordship, junior government.
Junior government advocate, Mr. So-and-so. Junior government advocate appears for the respondent number 1. Yes.
Yeah, please, Your Lordship.
Yes.
Your Lordship.
Which item?
Earlier, I forgot.
You forgot to what?
Mention that there is an interim in item number 24.
24, item number 24.
If interim may be
It's with
extended.
her, probably. You just note it down that interim order so passed shall be extended.
For admission, item number 18.
May I please, Lordship? Lordship, I beg to mention on behalf of IME, Lordship, if 3 weeks' time may be granted to me to file my affidavit in opposition, Lordship.
Mr. MS so-and-so appearing on behalf of the respondent number?
For the state respondents, Lordship. For the state respondents.
For?
The state respondents.
For the state respondents. Well, the state respondents submits that she is yet to. But you are appearing with all the respondents?
Yes, Lordship.
No, it can't be all the respondents. Or you're a government advocate?
Yes, Lordship. I'm appearing on behalf of my colleague, Lordship.
MS so-and-so, the learned counsel, appearing for the state respondents, submits that she is yet to receive the instructions from the concerned authorities and therefore prays for 2 weeks' time to complete her instruction. Prayer is allowed, let the matter be fixed after 2 weeks. MS so-and-so appears for the petition. Right?
Much obliged,
For orders on the supplementary cost list, item number 36 to 40.
$36 to $40.
Yes. May I please, my lord?
The IO is for what?
IS is filed for impleadment.
Impleadment of whom?
Plaintiff. Lordship, kindly peruse the last order. It was on the direction of this Honorable Court's order.
Last order?
Lord
Where?
order dated, that would be
Which IA?
in not in IA, but in WPC.
In WP, sorry.
IA has come for the first time.
WPC
40, yes.
40? Not 40. 40, there is no order, it seems.
I have a,
That 25/3/2025?
yes, 25/8,
25/3?
25/8, August.
This is written 25/3, then there
I
should
have-
be some other order. But this order is not there. This is in WBC number 40 of 2025. This order is not available in the record. Why? Is it somewhere else? Is there any other file for orders? It's not there.
There are 5 analogous matter.
It's not there. No order is there. Where? Check properly.
WPC 25/8. Justice Debashi. It's there, my lord.
Where? Which file? How come I didn't see it?
If I may read.
Yes.
Upon hearing the matters, this court has put a query upon such and such, the learned counsel appearing on behalf of the petitioners, as to whether the present petitions at all would be maintainable without arraying the plaintiffs in declaratory suit number such and such as party to the instant proceedings. Mr. Such and such counsel submitted that they would not be necessary parties, but they would be proper parties. In the opinion of this court, the plaintiffs in declaratory suit such and such as well as such and such are necessary parties, and without impleading them, the instant proceedings cannot be proceeded with. So therefore, liberty was given to the petitioner to implead. So Lordship, the reason why we have not impleaded, because we were not the party in the suit, declaratory suit, and in the first appeal also. And thereafter, we are only in the writ petition, we are only challenging the order passed by the deputy commissioner.
But they will be affected.
They may be, but we were challenging the DC order on the ground that any judgment passed in the civil proceedings cannot be executed against a person who was not a party. So the order of the DC
Anyway, there is an order from the court.
It's
The order from the
Lordship.
court. We'll implement it, we will implement them.
Lordship, but I have some prayer in that for impleadment. In the declaratory suit, Lordship may take my IA 190. 190 of 2025, the first IA.
190.
Yes. That IA in for
It is not numbered or what? One second.
item number 26.
193 or 190?
190. 190 is
One second, 190, yes.
all are same, Lordship. These are all analogous.
similar,
All are
correct,
similar.
Yeah, 190, yes, tell me.
Yes. Paragraph number 4.
Paragraph number 4,
The page number 3. That is paragraph.
yes.
So may I read, Your Lordship?
Huh.
That the declaratory suit number 6 of 2025 was filed before the Learned Civil Judge Senior Division, Dimapur, Nagaland, by one Sri Vihuli Khate. During the pendency of the suit, the plaintiff expired. Therefore, he was substituted by the following legal representative. So the first one is the wife. Second one is the
The 6 representatives,
total 6.
correct.
So I have a prayer. The next paragraph, sub-paragraph. As all the above mentioned plaintiffs 1 to 6 are legal representatives of late Vihule Khate, the applicant may be permitted to implead only the plaintiff number 1 and 2 as party respondents. One is the wife of the plaintiff and the second is the daughter-in-law.
But they were parties because they were representing this.
They were represented by the mother, that is its serial number 2.
No, correct, but like, you make all them parties. Why pick and choose? Because they have been represented there. They have their individual rights.
I was told that they must be minor.
This court is not aware. They have been made party there in the declaratory suit. If they were minor, how come they became parties there?
They were represented by the mother, that is its serial number 2.
No,
That is daughter-in-law of the plaintiff.
During the pendency of the suit, plaintiff expired. Therefore, he was substituted by the following representatives.
Yes.
So there is no question of representation. Or it may be represented by the mother before them, but they were parties there. And we do not know what is the age now. And this is the suit in 2005 suit. When the order was passed?
It was decided on 2014.
2014.
And then appeal was filed.
2014 is long time.
Yes.
If they were minor also down, by this time they have become measures. So you'll have to implead all of them.
Then I will implead.
Okay.
Besides impleading, we are not seeking any relief from them as
So
well.
you impleed all these parties. In all these petitions or the same parties.
And there was 2 declaratory suit. Now the present one which I have taken, Your Lordship, that is declaratory suit is number 6. And in 7, there was one party, plaintiff, but the nomenclature has changed, that I've stated in my paragraph number 5. The nomenclature has changed.
Let us go one by one.
So the next.
The first one, let me pass the order, then we'll change it accordingly, okay?
Oh, Lordship.
Heard Mr. So-and-so, the learned counsel appearing for
Applicant.
You put off your mobile. Put off your mobile. Heard Mr. So-and-so, the learned counsel, appearing for the applicant. Applicant in I number 190 of 2025 in WPC number 40/2025. The learned counsel appearing for the applicant submits that void order dated 25/8/2025. This court, a coordinate bench of this court has given liberty to the petitioner to implead the plaintiffs in the declaratory suit number 6/2005 as well as declaratory suit number 7 stroke 2005 by filing a proper application. In view of the aforesaid direction, in view of the aforesaid liberty granted to the petitioner, the instant application has been filed. The instant interlocutory application has been filed for impleading
Paragraph number 4.
These were the only plaintiffs,
Yes, in the declaratory suit,
Number
six,
six.
6, yes.
or any more are there? No,
No,
only
no,
this.
no.
Impleading the plaintiffs in declaratory suit number 2006. What was the line written? What was the line? Granted. For filing, for impleading the plaintiffs in declaratory suit number so and so, in comma that is you'll have to type it down from here. Paragraph 4, the names so and so. Full stop. The learned counsel appearing for you are appearing for whom? You are appearing for
the state.
For the state.
1 and 2.
Mr. So and so, learned counsel appearing for the state respondents do not have any objection in implement of the aforesaid plaintiffs in the instant writ petition. In the writ petition, in view of the aforesaid.
My lord, the order has to be passed regarding 7 also. This is for the same case only. This,
In a 7 will pass separately because this is 2006, right? So these plaintiffs are of 2006, isn't it?
6 of 2005.
Suit number 6 of 2005.
Yes.
For
So they
7
will have to be implemented together in the same WPC. In WPC 40.
Okay, you are the only one WPC, na?
One WPC. There are 5 different analogous, but it has to be in the one WPC.
In WPC only you have challenged the both. Both
the parties were.
Both the parties are there. Okay, then you write 200, but you have not mentioned about 7.
Lordship, next paragraph, number 5.
Paragraph 7.
Paragraph 5. Where the nomenclature has changed. So then 7 and 8 will be the parties.
As well as, you write the before the learned government advocate, implead so and so, as well as the plaintiffs in declaratory suit number 7/2005, that is
Third line from the bottom.
That is
Kuda
Raja, Kuda, Kuda Raja, RAZHA,
yes.
ZHA, then ANGAMIMIAPFU, then Kortho, KROTHO, and
represented by the president. That is the name of the president. Miss Tsuka Pese.
represented by MS Suka, CUKA, Suka, PESEYIE, represented by so and so, who is the president of CRAC, na?
CRAC, yeah, aforesaid.
That name we have given, na? Kuda Raja. In bracket you write CRAC in short, KRAK, all capital, CRAC in short, being a president. Then he doesn't have any objection, he have written. then in view of the aforesaid, so you'll have to file an amended cost title.
Amended cost title before the registry?
Before the registry, of course.
Yes.
In view of the aforesaid, the petitioner is allowed to file, the petitioner is allowed to implead the aforesaid plaintiffs as respondent number 3 to
3, 4, and 5.
no 3, 4, and 5. We'll have to include all.
Okay.
3,
4,
4, 5, 6, 7, 8, 9, 10. Respondent number 3 to 10, you can write 3 to 10 in the instant writ, in the connected writ petition. In the connected writ petition. Accordingly, the
Lordship, it will be 9, not 10.
huh?
It will be
It will
9.
be 9.
9, Lordship. Counting from 3.
3 to 9.
3, 4, 5, 6, 7, 8, and 9.
How many are there? There are 8, right?
6 and 7. Because I have sought liberty to implead only 2, but
No,
Lordship,
I'm not
Lordship are saying that to implead all the 6 legal.
So 3, 4, 5, 6, 7, 8, 9, and 10. Oh, there is represented, no? Yes.
They are represented.
It is 9.
9.
Correct. 9. So accordingly, the petitioner is directed to file the amended cost title before the registry within a period of 2 weeks.
1 week.
Within a period of 1 week. 1 week. Let the matter be listed after 2 weeks. The similar order will go in all.
Lordship, in the main petition, order has to pass for notice.
Notice hasn't been issued.
They have implemented by today's order. So
Correct. No, let you file a cost title, then you will issue notice. Because without cost title, how will I issue notice? You after 2 weeks, when the matter comes,
Lordship.
then notice will be issued.
Lordship.
Because the cost title is not there.
Lordship.
Once you give the amended cost title, then notice will be issued. In all the
similar order.
IS similar order will go, right?
Similar order.
No separate orders are required.
Not required.
All plaintiffs will be same.
Same.
I mean, they will become respondents.
They were only affected by the order passed in the first appeal.
Because I think this has been passed for a precautionary measure. If they are
Lordship, I
affected,
understand.
and they will again come, then again a multiplicity of the litigation. Problem will be, there will be a problem for you also later.
Lordship.
If they come later and copy for the court.
Lordship.
Correct. So it's good that you are making them parties.
Lordship, I'll take steps. Oblige.
You take it from there, huh? The IA, paragraph number 4. Paragraph number 4 and 5, the names.
For orders, item number 41.
Number? Yes, what has happened here?
May I please, Your Lordship? Lordship, as per this Honorable Court Order dated 13/10/2025, Lordship.
13/10/2025.
Yes, Lordship, page 10, Lordship.
Yes.
We were allowed to file the IA for impleadment of the respondent number 11.
Okay.
So we have filed this.
You have filed this IA.
Yes, Lordship.
Okay. Heard Mr. So-and-so, learned counsel appearing for the petitioner.
Yes, Lordship. Applicant petitioner.
Appearing for the petitioner. Full stop. The instant IA has been filed in terms of the order dated 13/10/2025 passed by this court. In terms of the order, let's see. You are not objecting to this, right? Instant IA has been filed by the petitioner for impleading the
Respondent number 11, Lordship.
Where is the paragraph?
Respondent 11, page 5, Lordship. Page 5 to the IA.
For impleting respondent number?
11, Lordship. Oh, yes, sir, 11.
Then who is that person?
Oh, Accountant General, Lordship. That is Sri Varun Aluwalia, IAAS. Accountant.
Okay. Impleting the present accountant general in bracket A and E in comma Sri Varun Aluwalia. This is not Varun Aluwalia, comma IAAS as the earlier principal accountant general in bracket A and E, all capital, Nagaland, has been transferred. Correct?
Lordship, he is in the same established as far as my knowledge. The one, the previous.
He's still there, this principal accountant general.
No, respondent number 10. So respondent number 11 is a new incumbent taking the charge of accountant general.
But he's still there, the 10 is still there.
Yes, he's still serving, Lordship, 11.
But why do you want to make him then?
Lordship, earlier we implemented respondent number 10 as principal accountant general.
If he is already there,
yes.
Why do you want to make this person Varun Aluwalia accountant general as party? And you have not stated anything why you want to make them. Yeah, you have written here, he has succeeded him. That means he has already been transferred. You have to strike out his name. See, paragraph 3 you read. That after filing the present contempt petition, Varun Aluwalia succeeded Sri Frederick so-and-so and is the incumbent accountant general.
Yes, Lordship, respondent number 11 is the new incumbent accountant general, Lordship.
Correct. So, I mean, now you still want this Frederick Simlia to be a party because he's no longer there.
Yes.
Huh?
No, Lordship.
You have written after filing the present contempt petition, Sri Varun Aluwalia succeeded.
Yes, sir.
Succeeded means he has taken his place.
Yes, yes.
And is incumbent accountant general. The Frederick Similia is still there or not? He's still there, Frederick.
Lordship, it appears that according to his statement, this fellow is still there. Frederick Shamlai is still there.
Lordship, we have filed this trustee affidavit on 19/19/2025, Lordship, to the contempt petition number 21 of 2025. Here, paragraph 2, Lordship. Here. Trustee affidavit.
Paragraph 2, the state affidavit is not there. The state affidavit.
Trustee affidavit. Lordship, we have filed.
Affidavit of service is there, yes.
Lordship, in fact, the council who has been representing the accountant general, his juniors is here. I think she'll be able to throw some light here.
Yes, that person is still there or he is transferred?
Lordship, the person is still there. However, he is in another section now. Now the new principal accountant general is Varun Aluwalia.
Varun Aluwalia.
Yes.
So then you'll have to strike down his name.
Yes, Lordship.
So we will state that in place of that earlier one,
yes,
you want to implement this one, correct? So yes. You'll have to strike down his name. You'll have to file an amended cause title, striking down his name,
yes,
and put his name.
Yes, Lordship.
क्या लिखा? To a different to a different section.
Yes, Lordship.
Different section of the department and no longer holding the post of accountant general.
Lordship.
Correct?
Yes, Lordship.
No longer holding the post of accountant general. His name should be struck down, and then his name should be replaced by the present incumbent, that is Sri Borun Ahluwalia, IAAS, as respondent number 10. You do one thing, you file a different petition, it will be difficult because in the cause title you have put all these people, then in the prayer also you have written respondent number 11. See, categorically, in place of so and so, in view of in view of the aforesaid, the petitioner is allowed to implead the aforesaid Borun Ahluwalia, the present accountant general, as respondent number 11 in place of Sri Frederick Similia. You take it from here, Similia, in bracket IA and IA and AS, all capital bracket complete. The principal accountant general in bracket A and E, all capital, Nagaland, Kohima as respondent number 10. Respondent number 10. Accordingly, the petitioner is directed to file an amended cause title in COP, all capital, in bracket C, number 21 of 2025, within 2 weeks before the registry. Correct, before the registry. Let this matter be fixed after 2 weeks.
Much obliged.
May I bless your Lordship?
And record that his name, his name. You appeared for?
Respondents 5 and 6. Respondents 5 and 6.
Mr. So-and-so appears for respondent 5 and 6. And you appear for?
1, my lord.
Mr. Angami appears for respondent 1, and you appear?
We have instruction to appear for the newly impleted.
Others
Let notice may be issued.
The notice will come after the amended
Lordship,
constitution.
Lordship.
But as far as this thing, other respondents?
No, Lordship, I'm not appearing.
You're not appearing.
Lordship, I'm appearing for respondent 2, 3, 4, 7, 8, and 9.
Right, so-and-so appears for this one number so-and-so.
May I bless your Lordship? Your Lordship, sincere apology for intervention, but if I may be allowed to make a mention on item 23, Your Lordship. I've been waiting for this matter, Your Lordship. However, I've been informed by the court master that this matter has already been adjourned. So, Your Lordship, in this matter, there is an interim relief.
Item number 23, note down. 23, C has taken it. That interim order so passed earlier shall be extended till next week.
Obliged, Your Lordship.
You are for respondent? 1. Respondent 1. Yes. COP always 1. Each 1. No. Different. And Angami is a government advocate. No more is a private advocate. both are Angamis, but they are two different persons from different villages. Hello? Hello, G? Yeah, yes, what kind of favor? Motion item 23 to motion na hai. Admission there. Only be 2 weeks adjourned position. Why? Yes. I can't recollect. I think government advocate was not there, that's why. It was supposed to be represented by one V. Sokre or like that, but government advocate were mentioned over here. What? Yes. No, after 2 weeks. Yes. Yeah. Okay, have a good day, boss.